Morning, Judge Trotter Brandon. Carl Lewis on behalf of Alandis Moore.
Good morning.
As he comes out, I think.
Judge, there is a request for an order of protection. Amber Norman,
President.
ma'am, get your ID to show the deputy, please.
Carl. Yeah. Your Honor, as he comes out, we're going to waive probable cause, Your Honor. The complaining witness is present with identification, is not requesting a protection order, Your Honor.
Good morning, ma'am. What would you like to say?
That I'm not afraid of him, so I don't do it.
Are you concerned for your safety or the safety of someone else?
No,
Has anyone threatened or coerced you to be here today? Are you saying that this incident didn't happen, or you just don't want him in jail?
I don't.
I'm sorry, Judge.
She said, I just don't want him in jail. All right. Is there anything else you want to say? All right.
Thank you.
What
May
are the
please.
allegations?
Your Honor, in reviewing the paperwork provided this morning, it appears that the defendant kicked in a locked door to the apartment. The victim had barricaded or got to another bedroom, locked herself in, and got in that room. It looks as if he pulled her off the bed violently, pulled her hair. She was on the ground, she was covering her head, and he was striking her. Officers did observe a cut on her hand or finger, which made, which they felt was consistent with the addition of events that was given to them by the victim in this case. In addition to that, I believe they also saw locks of hair on the floor. It appears that children were present.
Your children on the.
Thank you, Judge. Lifetime resident, they are very, very close. He actually had a key to that apartment. We're not going to try this today. With respect to asking for a bond, I'm going to ask for OR. He self-surrendered. We've discussed this case, Your Honor, and the complaining witness is present today, is not requesting TPO, is also asking that he be released. So again, I understand it's a felony one is charged. I doubt seriously that the grand jury will return it the same. I think it will come back as a trespass at best. And again, I would ask for OR bond self-surrender.
Is Miss Norman still here?
She is, Your Honor.
Do you want the protection order? I did not ask.
No,
that.
ma'am.
You don't want an order for him to stay away from you?
No, ma'am.
All right. From the state?
Thank you, Your Honor. We are going to request a monetary bond, and in addition, during the pendency of this case, a stay away, no contact, just due to the nature of these allegations, as well as the level of the offense. It's charged as an F1, aggravated burglary is violent felony. So we would ask for that as well. Looking at his record, he does have a long history of drug trafficking. Officers did observe damage to the door as well as the injuries previously noted.
May it please the court. I respect whatever the court does. I respect my colleague, Mr. Hickenlooper, but we have the complaining witness present. And again, we're not going to litigate. Looking at the purposes of bail, Your Honor, my client did self-surrender, has substantial ties. Court wants to impose a monetary amount, and would actually be nominal. Again, the court can understand, but Mr. Hickenlooper may not. She does hair for a living. So that was not as a result of injury. That's hair in the area from patrons that she does hair for. That I will remain silent.
So Mr. Moore has 8 felonies, 1 misdemeanor, 2 prior failures to appear. I will not order a TPO at the request of the prosecuting witness. This is an F1, but based on what's been said from the prosecuting witness and no prior history of violence, the bond is $15,000 anyway, plus EMD, plus, well, she doesn't want juries. The parties do not live together, correct?
Correct, Judge.
He has somewhere else to stay. How far is it from where she stays?
How close is it to her residence? He says it's gotta be, it's outside the radius, Judge.
This will, I know that prosecuted witness doesn't want to stay away. I'm putting it in anyway. It's gonna be EMD with a 3-mile radius from the prosecuting witness's house.
May it
So
please,
if you go within 3 miles of the home, you'll be violating the EMD. Understand?
Your Honor, may it please the court, is that EMD, open hours?
I'll do open hours.
Thank you, Judge. So,
Judge, he is under a disability, it appears, so he may not have firearms. Just the court would advise him of that.
that's a good question. Your Honor, he raises a very good, I'm sorry. May it please the court. He raises a good point. The logistically, are you ordering him to be fitted first, or if he posts bond to report to EMU? I don't want to
If
see.
he posts bond, then they would put it on here, I believe.
Correct. Sometimes they sit
Before
2
he
3 days.
leaves.
Okay. Thank you, Judge. Grand jury report. please.
Grand jury report date be 11/10.
Thank you.
Next is Gonzalez. I believe that
Thank you,
is the
guys.
city.
Thank
City OBI.
OBI,
Something schooly, as Bugs Bunny would say.
Your Honor, if it please the court, I think the judge's sheet may have an error because yesterday we were in error. The city thought this was a 4th and 10th. We looked into that further. This would only be a 3rd.
Es la tercera vez, no la cuarta, ha habido un error
So
administrativo.
this is a third,
Es la
10,
tercera
fourth
vez
overall.
y la cuarta
No,
en total.
third overall also.
No, la tercera en total y la tercera en el periodo legal.
No accident,
No
no
hubo accidente, no
insurance,
mostró seguro,
ALS and a refusal.
hay suspensión
Correct. All
administrativa y
that's
se negó a hacer el test por el médico, todo lo que ha dicho es correcto.
So Your Honor, as to bond, he was given 2 $20,000 bonds, 10% yesterday. We're satisfied with that bond. We would ask that the TAD and EMD be removed due to the monetary bond is sufficient to bring him back to court. He's a citizen, he lives here in Price Hill with his family. I have good contact information for him. He has 0 failures to appear in the last 5 years. His ORAS score is listed as a 2. He's getting one of those points from allegedly only being part-time employed, but he works full-time at Mi Cabaña. In fact, he just gotten off a 15-hour shift when this happened. So I would ask the court to remove that EMD and TAD requirement.
Your Honor, we ask you to maintain the TAD. The bond as it is already set. He has reasons in these facts alone to be concerned about an alcohol problem with Mr. Gonzalez, but having the record as we do, for 2023 and 2021 convictions for OBI, and here again, 3rd with odor of alcohol, bloodshot watery eyes. He blew through a red light prior to being stopped.
Cuando le paró la
The
policía.
TAD, make sure he's not
El monitor
drinking and
electrónico
driving, because
de
it'll make sure he's
tránsito
not
nos
drinking.
aseguraría
He's not allowed
que
to
él
drive, he
no
has
bebe,
ALS.
no bebe.
We
No se le
understand
permite conducir y tiene suspensión
We want to
administrativa en vigor.
prevent him from.
The only modifications that the court will make to the bond is to remove the
Es le
EMD.
voy a quitar
There is
el
nothing
monitor
to
de
indicate that
localización.
Mr.
El
Gonzalez
monitor
will not
térmico
return
se
to court.
mantiene y
The
la
TAD
se
unit
mantiene.
will remain on,
El monitor
which
térmico se
monitors if he
mantiene
consumes any
para
alcohol.
detectar
No
si consume
alcohol is
alcohol.
also a condition of
No puede usted ingerir alcohol, esa es una de las condiciones de
Your Honor, thank
fianza.
you for that.
monetary bonds, stay the same as was said
La
yesterday.
fianza monetaria se mantiene tal y como se le impuso ayer.
Thank you, Judge.
Gracias, su señoría. Thank you, Your Honor.
Thank you.
Lattimore. Judge, I believe this is off the 10:30 docket.
That's correct, Your Honor. I'll move to waive her appearance. The related felony was indicted, and it's my understanding that the city is going to dismiss the traffic case.
Yes, at my request, please dismiss that plate charge. The felony in play. Thank you.
Fout.
Morning, Your Honor.
Your Honor, this is a bond revocation.
That's correct, Your Honor. Tyler was on a stay out of Judge Mallory's mental health court docket at Parkway Center when this occurred. We will submit on the allegations of the bond revocation. Note that there is a holder, it just as the court to set some bond. And then I spoke with the mental health court coordinator. I can either do this across the hall, but ultimately we would just like to put on Judge Mallory's mental health court docket next Wednesday. That would be the 5th at 1:30 p.m. in room 240.
Anything from the state?
Judge, just that the basis is that he was discharged from Parkway for inappropriate disruptive behavior. So we would ask that he be put on the judge's docket as soon as possible.
Bond 5,000 anyway, continue back to the mental health court docket, room 240, 1 p.m., November 5th.
Thanks, Your Honor.
Wells. All right, dude. All right.
Morning, Judge.
Good morning. Good morning, Mr. Wells.
Judge, I am filling out Ms. Colbert's designations right now. We will be asking for a nominal bond. There is a holder out of state. I believe it's in Boone County. I don't know what the holder is for specifically. So we would just ask for 1,000 at 10% or 500 because we all love Diamond. She's fantastic.
And I've been doing so much better at getting a job.
I know you have, I haven't seen you in a while, but let Mr. Montgomery talk for you, okay? All right.
Happy to stay away from wherever the allegations are in the story.
In the county, it's Nordstrom Rack.
Yeah, this is an independent person, and James H. Freemoff stole $50 cash. So we definitely want to stay away from him, but I am, looks like the court knows him as well, but I as well have had experience with her theft offenses, so I take those very seriously, that she says she's doing better, but here she is accused twice now, recently, of theft, and I know she has at least 30 convictions for theft, so it's a concern. Maybe we need an EMD at least in this situation to keep an eye on her whereabouts.
I'm not going to do EMD because it's not been successful in the past. There are 4 violent felonies, 4 felonies, 1 violent misdemeanor, 43 misdemeanors, 19 prior failures to appear. The bonds will be 5,000 anyway on each count.
Straight.
No.
No, anyway, 10%.
Vaughn. Vaughn.
Good morning.
Good morning, Your Honor. Aaron Levinson on behalf of Mr. Vaughn, entering a plea of not guilty.
All right, waive probable cause on the felony.
Yes, Your Honor, I believe he was arrested on a warrant.
Esteban.
Judge Esteban, these allegations are from 2023. It's not clear to me why it's taken 2 years to have him taken into custody. This is obviously unusual, and I would ask the court to take that into consideration when setting bond in this case. My client doesn't have any felony convictions since 2018. He's otherwise been someone that has been law-abiding and staying out of trouble. He is a homebody who stays at home with his family and is the primary caretaker to his children. We are asking that a reasonable bond be set in this case.
from the state?
Your Honor, as to the delay, I think that he was arrested on these warrants in Covington, Kentucky. So it appears that he left the state after this event and was located in that jurisdiction. Additionally, looking into the background, it does appear he has some other contacts in the Commonwealth. The allegations in this case, occurring on November 4th of 2023, officers were dispatched to 2 Poplar Street for a shots fired call. They got to the scene, they went to the apartment, and they could hear sounds inside the apartment as it reads, like someone stumbling around and groaning. They knocked on the door several times. They made contact with the victim in this case, who they determined had been shot and had a gunshot wound in his wrist or hand and in his abdomen. It was unclear to that victim at the time whether or not he was shot twice, once in the wrist and once in the abdomen, or whether or not it was a single bullet that created both wounds. The officers then further recovered multiple .40 caliber bullet casings and 1 9mm bullet casing. As they conducted their investigation and followed up, the victim indicated that he heard gunshots. He actually observed an individual inside the fence on the patio, and then there were bullet holes in the window to the apartment as well. He heard gunshots, and then he went upstairs to make sure his children at the time, who were 8 and 9, were safe, and he told them to hide in the closet. He went back downstairs, heard more gunshots, and he did not own a gun and did not shoot a firearm. He said that, and I should also point out, there was a 9mm casing and a firearm that was recovered, a Ruger LC9, which I believe is a 9mm firearm. And officers asked if that gun was his. He denied that. Apparently, there are security cameras in the front and the rear that recorded the incident. And then the officers located a vehicle, a Buick, Park Avenue, which was abandoned at 300 Oak Street. And that was attributed in belonging to Mr. Vaughn. And then witnesses also stated that Mr. Vaughn told them that he was going to go hang out with a friend at 2 Poplar Street, which is the location of the offense, which is just before the shooting occurred. When the Buick was found abandoned, it had a bullet hole in the side with blood inside. And then apparently he went to go retrieve, Mr. Vaughn went to go retrieve his cell phone from St. Bernard Police, and that those officers noticed a bullet hole in his wrist. Nevertheless, after that, they had developed Mr. Vaughn as the primary suspect in this shooting and issued the warrant. Judge, we are going to ask, because this involves a shooting in someone's home, there is ample evidence for probable cause that the weapons were fired into the home with bullet holes in the window, and the individual being shot. We would ask for a high secured bond with EMD, jurors if requested, no contact, stay away, and no firearms.
There are 2 prior felonies, 1 violent misdemeanor, 1 misdemeanor, 1 prior failure to appear. While these allegations are from 2023, it appears though that Mr. Vaughn had cases and had been in Kentucky cases in Kentucky in 23, 24, and 25. 25 looks like a fugitive warrant, so that may be this case. On the breaking and entering, 100,000 secured plus jurors if requested, no firearms. On the felonious assault, 150,000 secured plus jurors and no firearms. On the attempted murder, 300,000 secured plus jurors and no firearms. The improper discharge of a firearm into habitation, 75,000 secured plus jurors plus no firearms.
Your Honor, grand jury will be 11-7, 11-7.
Thank you.
Your Honor, that was the last early call. We're on to the city domestic violence docket.
Who has who? I have Collins.
Collins, John Collins. That was your protection order, please.
We're off the
Oh, it's a,
Yeah, we're
kind of, this is a cross complaint.
All right,
There's also Gabriel Kirk.
who is the cross complaint?
Kirk Fritz, who's actually up next.
All right, let's bring.
She's coming down, Judge.
I am correct.
This would be a copy. Oh, you do TPO too, I mean, that's true, that's.
All right. We will start with Mr. Collins, Mr. Ms. Kirkendride, do you want a protection order?
In speaking with her, Your Honor, she does not want a protection order.
Mr. Collins, does Mr. Collins want a protection order?
In speaking with Mr. Collins, he does not wish to have a protection order.
Do the parties do not live together, correct? I have two different addresses on these protection orders.
I believe that they can't say.
All right, as to bond, Mr. Collins.
Judge, he has zero failures to appear. He did get a little hit in the head, but he will stay away, or excuse me, since there's no stay away. I believe this will end in a quick resolution, asking to get Mr. Collins out, allow for him to get a new attorney who will be conflicting off this case. I'll be turning it into my office just to ease the process, move it along as quick as possible. We would ask for an OR today for allow for him to start that process.
Speaking with Ms. Kirkbride, she does not oppose an OR bond. She does wish to move to dismiss this case at this moment in time. I explained that this is arraignment. This is not that time where this can occur. It does need to be set for the dispositive setting, but we do not oppose the OR.
From the state.
Your Honor, the state sees this differently than defense. It's not very often that I see so clearly visible injuries from two people in the courtroom that they are violent with each other, and that's a danger to them both. And if they don't realize that they're incorrect, they need to stay away from each other. The city, I think, will be prosecuting these charges whether or not the victims want to do that, but we'll see what we can do. It's alarming when I see people like this on misdemeanor charges. So I want who's going to pay their bond and accept each other. And if there's a money bond, keep them away from each other. Excuse me, I don't mean to be upset, but
Is the state requesting a money bond?
yes, and I'd also like to verify addresses because the complaints do charge them at the same address. So not being able to confirm where they're going to stay. So an EMU component might. I mean, I want to stay away on these whether the TPOs are signed. I understand the policy of this court might be different than my request to make them sign it anyway. And of course, you'll consider the record and the failures to appear if those are relevant.
Ms. Kirkbride has 2 prior failures to appear. Mr. Collins has 3 violent felonies, 7 felonies, 10 misdemeanors, 0 failures to appear. Mr. Collins is here present with some injury to his head that's wrapped up. Ms. Kirkbride is here with scratches on her face and 2 black eyes, one of which is almost swollen shut. I understand that both parties have requested OR bonds. Based on the bond factors and Mr. Collins' history of violence, it'll be $10,000 anyway, plus EMD, plus a stay away order. I understand the parties don't want to stay away, but that is a condition of bond, that you all are not to go around one another unless your bond can be revoked. Ms. Kirkbride has no violence at all on her record. On the assault, 1,500 anyway, plus EMD, plus stay away. On the domestic violence, 1,000 anyway, plus EMD, plus stay away. Same, Ms. Kirkbride, you're not to go around the prosecuting witness. No calls, no text, no email, no social media, unless your bond can be revoked. Understand? All right, thank you.
Your Honor, thank you. McClinton next, Charles McClinton. There is a motion here for the child. And there is a child on it, Elijah, oh, I'm sorry.
EM.
Is, anyone named Bowen in the courtroom? Bowen? Desiree Bowen?
Desiree?
Not guilty on behalf of Mr. McClennan.
All right, Esteban.
Esteban, he is 37 years old, does have a separate address, did give me that address here. I show this as a non-living situation. I'm only showing one criminal contact, a 2016 possession charge. That was marijuana. I confirmed it this morning. 0 failures to appear. We're asking court for an OR bond. The allegation is threw a can at this individual, causing pain, and the reason the police charged him was because her clothes were wet and there was liquid on the floor. I do have that he attended college, went to NKU as well as the Music Institute. He's been employed with UPS for almost 3 years. I believe the OR bond with regards to the TPO judge would be sufficient. I would ask that the child be removed. There is no allegation in the complaint or the affidavit that there was any kid present for this.
From the state.
Yes, Mr. Montgomery's put it out there pretty well. There's a can being thrown. It does say it hit her in the head. It hurt. So there's additional things. The child is young. This prosecutor always presumes that a young child is in the custody of their mother. I'd like her to not have to deal with Mr. McClinton, at least not directly. There is a TPO in place for her. And if you were to strike the child, I would understand, but I would rather you keep the child on the TPO.
What is the,
There's no allegations in the affidavit or the complaint or what
about the child?
that the child was present, other than it's a 4-year-old, so it very likely was present.
Does it have the time of day this allegedly occurred?
Let me tell you if I have them. Sure, 21:49 hours was the arrest. Offense was 21:06, so late bedtime.
I'll take the child off because there is no allegation toward the child and no indication whether or not the child was present. And he is executing the TPO.
He has signed it, Your Honor.
As has been stated, Mr. McClendon has no record at all except for a marijuana ticket from almost 10 years ago. No failures to appear. He's executed the TPO. It will be, there's no allegation of a weapon in the sense of knife or gun. The allegation is that a can was thrown at the victim, causing pain and liquid on the chest and on the ground. It will be a OR bond plus juris if requested by the prosecuting witness. If the PW does want juris, I will make the EMD open hours. He just cannot go within the 3-mile radius of the prosecuting witness.
Note our objection to Juris here, Your Honor. Juris would hold him unnecessarily if Juris is unsuccessful in getting in contact with us.
So noted.
Thank you.
Where's it about 10 minutes?
Phipps, Sarah Phipps.
Isaiah Ty.
Are you Isaiah Ty? You'll have your ID out for the, yeah, well, here, take this in. Oh, this has a child.
It's good. You find it's a natural.
All right. Yes, sir. What would you like to say? Just speaking to the box right there.
As far as what, I'm sorry.
What did you want? Well, I'll ask you the questions. Are you, do you want a protection?
No, no ma'am,
Are you concerned for your safety or the safety of any children?
no ma'am,
Did anyone threaten or coerce you to be here today?
no ma'am.
And do you have a position on bond?
I'm sorry,
Do you have a position on bond?
what is, can you,
Whether she be let out without having to pay a bond, whether there's like electronic monitoring?
yeah, I'm asking that she be OR.
Okay. All right. Thank you. Did you want to say anything else?
No ma'am,
All right. Thank you.
thank you.
Not guilty, Your Honor. With regards to Ms. Phipps, I am showing no history, non-live-in situation. She does have a separate address over in Newport. I got good contact information for her. She is currently pregnant. I'm ask the court to consider the OR bond. I'll submit based upon that.
From the state,
I will ask for a stay away during the pendency of the case, even without the TPO that he doesn't want. The allegations are that she threatened to kill him in front of the police after she admitted that she pushed him. So that's where we get the two charges. I don't object to an OR with the stay away.
so the hit that is here in parentheses is a push.
Hit him in the chest is the language I'm reading.
Where the push come from?
Sounds like, where did the push? Oh, did I say the word push?
Yeah, so there was, only threats made, it was no hitting, nobody hit anybody. It was just a lot of grabbing and just pushing. Now, nobody struck anyone. When the police got there, they were kind of antagonizing her You know, I already told him that she was irritated, she's pregnant, she has emotions, she's upset about something. They kept talking to her, telling her to shut up. And then, you know, people get mad and say things that they don't mean.
Thank you.
Okay,
One
thank you.
question.
No,
Mr. Todd,
we don't need to do that.
Mr. Todd, you weren't in fear with
I already
anything
asked
she
you.
said.
We don't have to do it. She has no record, no failures to appear. There was no weapon whatsoever. The prosecuting witnesses does not want anything. Based on that, it'll be a straight or bond.
I was just establishing the subjective belief of fear.
Don't try to pick.
I'm not, I'm just crossing elements off, Your Honor. I'm on
Yates.
Yates, yes.
Not guilty with regards to Mr. Yates, Your Honor.
All right, as to bond
Seeking a nominal bond adamantly denies the charges.
from the state.
He's got substantial felony
Mr.
bond.
Yates, yeah, here in the Justice Center, he's making calls out in violation of a protection order that's in place to a Melissa Snyder. I don't know what to do with this. He has to keep staying away from her. He's not, but what can we do?
$5,000 secure plus juris if he gets out and makes that bond. Mr. Yates, you cannot have any contact with the prosecuting witness. That includes no calls. When the jail says that they're recording the call, they are not playing with you. They are recording the call. So do not call the prosecuting witness. Each call you make can be a separate charge for violating a protection order. Is that understood?
Yes.
All right, thank you. All right, before we start the felony lockup docket, I have 2 warrants.
Court is in recess.
I don't think so. You get in that element.
Andy? Zachary Gray, who I have as a walk-in.
Zachary, what's the last name?
Yeah, it's, or Crary, C-R-A-A.
Yes, what about
R-A-R-Y. Is that a warrant return? Okay, just-
Court is back in session.
Are you sure there's no R?
Hassan Abernathy.
Your Honor, both of these will go to the grand jury. I do not show a ALS form in the jacket.
What number OBI is this?
I believe it's his second in time. His first one came, looks earlier this year.
Was there an accident?
There was not an accident in this case.
insurance
Or, excuse me, yes.
test.
Judge, this was a refusal. I have that is the C charge.
And no ALS.
And there, at this point, it does not indicate one way or the other because I don't have the pink form.
All right.
Jamila Bashir on behalf of Mr. Abernathy. Judge will waive probable cause and ask to be heard on bond.
Ask
As the bond, Your Honor, Mr. Abernathy is 30 years old. He has no felony history, no Hamilton County criminal history, besides some traffic violations, Judge. As the state indicated, no crash. He fully cooperated with police, it looks like. Judge, his main concern is his job. He does work in warehousing. He is in fear that the longer he stays in the Justice Center, he would lose that job, Judge. No failures to appear, low risk assessment score of just 1. We're asking the court to consider OR, OREMD, and the alternative with open hours.
from the state.
Judge, it looks as if he may be on probation for the previous OBI from Butler County. He does have the OBI suspension. During this traffic stop, the troopers did locate a firearm in the motor vehicle, which was loaded, which was under the driver's seat. We would ask, in addition to monetary bond, and during the pendency of these cases, no firearms, a public safety suspension, and TAD, as this appears to be the second OBI offense in this year. And no alcohol.
We will impose a public safety suspension. On the OBI, 5,000 anyway, plus TAD and no alcohol and public safety suspension. On the driving under OBI suspension, OR plus TAD. On the refusal, because there was a bond on the A, the refusal is a OR plus TAD plus no alcohol, public safety suspension. On the improper handling, OR, I am not going to order a no firearms order. Mr. Abernathy has no record as an adult or juvenile except for the one prior OBI. Does not look like he is legally unable to possess a firearm. So the court will not order a no firearms.
Judge, 11-7 for grand jury. And I'm sorry,
everything?
it was, yes, everything.
Okay.
5,000 on the D charge.
On the A.
Okay. and
The A
then-
was the OBI.
Correct. And then the
And
OBI.
OR on everything else.
Okay, thank you.
Autumn Alley,
Good morning, Your Honor. I'm submitting Timothy Bicknell's designation for Ms. Alley.
Judge, there is a co-defendant with this. Later on this morning, Mr. Long, who is the co-defendant. I just want to make sure.
who is Mr. Long?
I'm Mr. Long's attorney.
Can we bring Mr. Long down?
Long?
Yes.
Is that a felony or a misdemeanor?
He's a felon.
Damon Long?
He's charged with the same,
Yep.
same.
Damon Long.
Judge,
Come on. Well, I'm a very good attorney. He's gonna be up there waiting and doing all the talking for you.
with respect,
Good morning, sir.
with respect to probable cause for Ms. Alley, Judge will waive, although I note that this sounds like a lower level burglary than an F2, but I don't think that's a probable cause issue. It just has to be heard on bond when the court's ready.
All right. And waive probable cause?
Yes, Your
as
Honor,
well?
same situation.
As to, for Ms. Alley.
Thank you. Judge, the prosecuting witness here is Ms. Alley's sister. Her name is Essence Alley. And Ms. Autumn Alley has been living in this residence since July. She was given a key. I explained to her that situation, because obviously her sister's mad at her now. So I explained to her that this situation is not going to be corrected and that she must go someplace else, even though she had been living there. She tells me she'll either live in a shelter or she'll go to 784 Greenwood, which is her mother's address. Your Honor, she's 25. She's a lifelong resident, a graduate of Withrow High School. She's currently not working. She's a full-time caregiver for her mother who's in hospice. I don't know how this is gonna come back from grand jury, Your Honor, but we'd ask the court to consider supervised OR.
Mr. Long.
Thank you, Your Honor. We are also asking for an OR bond in this case. The residence at issue is a place he was living. This is a unique circumstance. I know the charge reads burglary, but I think this will work itself out in a very different way. Obviously, the circumstances are such that he knows he cannot go back there if he's released and will find an alternate place to live. But the charge and the severity of it don't warrant the bond that you would ordinarily grant in this circumstance.
From the state?
Your Honor, taking into consideration each individual record, appears that Ms. Alley has very little record. Not quite the same situation for Mr. Long. We'd ask for appropriate bonds, stay away, no contact from the location and the property lessee or owner in this case.
Ms. Alley has no record except for a minor misdemeanor marijuana possession in 2018, one prior failure to appear, nothing else. It looks like the 527 said that they forced their way into a window, but the complaint did say that they entered by force and then they were asked to leave and refused to leave while the tenant and landlord were present. On Ms. Alley's, while this is an F2 based on the allegations and the familial relationship, as well as the address that it has on my sheet, Ms. Alley and Mr. Long living at is the address of the alleged burglary. It will be a supervised OR.
Thank you. Judge, is that supervised as to both?
That was Ms. Alley. I'm gonna do Mr. Long's now.
She getting a grand jury date?
11/12 for Miss Alley.
Mr. Long has a considerably longer record with 48 misdemeanors. But with the facts of the case and the address of the alleged incident being one where he actually lives, the allegation of not leaving when told to do so appears to be more of a trespass. So I will do an SOR bond, supervised OR bond on it as well.
Same.
All right, thank you. Have a good day, sir.
Barnes, 11, same grand jury date on the SOR.
Thank you. Mark Little, sorry.
Kenneth Barnes.
Your Honor, on behalf of Mr. Barnes, we waive probable cause.
All right, Esteban.
Esteban, Judge, He lives in Western Hills by himself. He works at the janitorial service that he runs. My understanding is that he was in a car. He was the passenger in the car. He was smoking some weed. They pulled the car over. They found weed in the car. They've now charged him with trafficking. I believe it's 85 grams of marijuana is the allegation here. It's a charge as a felony 5. I don't think he was trafficking. I think he was smoking in the car, which is not necessarily a smart idea. He was not the driver. And we would ask for an OR bond at this point in time.
From the state.
Judge, F5 marijuana, nothing additional.
Supervisor.
Emily Berg. Oh, I'm sorry. 11-12 on an SOR.
Figure we get that.
11-12.
Thank you, Judge.
Your Honor, Emily Berg was not brought down this morning. There is no objection to a one-day continuance. We hope to be able to assign a lawyer tomorrow.
She didn't beat up.
Sorry?
She didn't beat up.
We'll defer to deputies on why.
With regards to Ms. Berg's probation violations, Your Honor,
You want to set those tomorrow?
we can set those over tomorrow. I believe the court's going to be inclined to bring her back in next Wednesday and address the situation on Wednesday. So one day continuance for arraignment tomorrow is not the end of the world. We would just ask for a nominal bond.
Well, I'm gonna put one.
Tomorrow's the 30th, yes. Tomorrow's the 30th.
Yes.
Quarters in recess.
Next up will be Betts. Hey, that's right.
Daquan Sims, just the traffic stuff. I'm ready to get started. We tweet the eggs at 45 unclassified property.
I think we probably can.
I thought that'd be a.
You know, probably not out of the realm of possibility. I mean, grab it.
No crash.
Good morning, Judge. Mallory Reed on behalf of Mr. Betts. Will waive probable cause.
Esteban.
Thank you, Your Honor. Esteban, Mr. Betts is 41 years old and he's a lifelong resident of Cincinnati. Judge, he has an OREF score of 2. He has 0 failures to appear in the last 5 years, which is likely because his last criminal case was in 2013. He's had just a couple of, I think, traffic tickets since then. Your Honor, this is an allegation of weapons under disability. That disability is, from what I can tell, from 2005, so a 20-year-old disability, and that disability is just possession of drugs, which I think was an F5. All of that being said, he is working. He works at Richards Industrials. He's been doing that for 8 years. He works as a shipping clerk there, but he's had a lot of different jobs at that company. He is a high school graduate. He has 2 children, ages 17 and 14, who live with him, along with his father, who has some health issues, and also the mother of his children, who also has some health issues. So he takes care of a lot of people. As to the facts of this case, he was in a car accident that he was not at fault for. He was not charged for that accident. When the police came, he was in the ambulance. He asked for his possessions out of his car, which somehow led to the police searching in a backpack, which I find interesting. All this to say, though, Judge, the disability is a drug possession from 2005. He hasn't been in trouble in over 10 years. We're asking for an OR bond.
From the state.
Yes, Judge, it appears that When Mr. Betts asked for his backpack, the officers retrieved it. It felt heavy. Officer felt what he believed to be a handgun in from the outside of the backpack. They recovered a handgun, and it appeared to have a fully loaded magazine in it, but not one in the chamber. Looking back, he has the 2013 attempted trafficking and a possession of cocaine from about 20 years ago.
Mr. Betts has 5 prior felonies, 3 misdemeanors. As counsel stated, the last conviction was a disorderly conduct, I believe minor, in 2016. Nothing else before that since 2013. Nothing of violence, no other gun offenses. This court usually sets higher bonds on heavy weapons while under disability, but based on the facts of this case, the alleged disability being 20 years ago, and the suppression issues raised by the defendant at this stage, be a supervised or
Judge, just
with no firearms. You legally can't have them right now, but I'm also, it's a condition of, understand, sir? Thank you.
Judge, and grand jury will be 11/12.
Tyree Burton.
Thank you, Your Honor.
Thanks for your attorney.
Here, Mr. Burton.
Good morning, Your Honor. Darcy Winston on behalf of Mr. Burton. I am going to be representing him on everything, so I turned in my designations. Yes, Your Honor. As to bond, Your Honor, I did speak with Mr. Burton. We are aware that he does have a capious bond for probation violations in front of Judge Bill Mallory. So we are asking for a nominal bond on everything else, Your Honor. Regarding the breaking and entering, I will note that the allegation is from April, which was before I even picked up Mr. Burton. It looked like there might have been some testing done, but I will note that that place that they're claiming, the AMCO Transmissions and Total Car Care, has been permanently closed for months. So I'm not entirely sure if this will survive grand jury because the place that they're claiming, the prosecuting witness, that place no longer is open. So we are asking for nominal bonds on everything. I just wanted to point that out, Your Honor.
From the state.
Judge, it appears that in this particular instance, back in April, he may have barricaded himself temporarily inside that location or inside a camper at that location. After several minutes, he did surrender himself. And he does have a prior history of B&E in a trespass.
So his Judge Mallory set a $10,000 capious bond. That'll remain the same. I'll do $1,000 anyway on the others because of the $10,000 bond that's there.
So 1,000 on the felony, which would
$1,000 on everything else.
grand jury would be 11/7.
Is that on everything that correct?
Just the breaking and entering will go to grand jury. Everything else should go to the assignment commissioner.
Okay.
Does he have a holder?
No.
For an open case?
No.
Judge Hathaway?
No, that's active. I'm representing him on that. He's not got a holder here in this court for that.
So 11/7 for grand jury.
Thank you.
Joshua Sarah.
Judge, this was continued from yesterday.
Is Mr. Sarah able to come down today?
There is a request for an order of protection. Caroline Larrell. Thank you.
Your attorney.
All right.
Good morning, Aaron Levinson on behalf of Mr. Sarah. Aaron pleaded not guilty, waive probable cause.
Esteban.
Judge Esteban, my client has an ORAS risk score of 2, with no prior felony convictions. He himself has some significant medical issues. He was stabbed in an incident back in May of this year and has been undergoing serious mental issues related to brain damage. He was supposed to be having a angiogram yesterday related to that. So he has very good medical reasons for him to be out. As far as the allegations in this, we'll wait for this to sort itself out. I think the vast majority of the allegations, based on the statements of the witness, I'm not aware of corroborating evidence that's been included in the complaints. I think this witness has previously made and then retracted allegations. We are asking for a reasonable bond to be set in this case. Thank you, Your Honor.
From the state.
Judge, we are going to ask for a monetary bond, EMD, juris monitor if requested, and new firearms in this case. Looking into his background, we find some concerning issues, particularly out of the state of Wisconsin. The domestic violence that's charged currently in the count D of 19002, we believe should be a felony. It looks like there was a prior domestic violence or domestic battery from Wisconsin in 2024. There is an extensive history of the defendant in Wisconsin. During this incident, the victim reports that with one hand choked her, which almost made her lose consciousness, repeatedly punched her in the head. During the altercation, he exclaimed, "This time you're going to die." He then threw a knife at the victim after she broke free from his grip. He refused officers' commands to come out, show his hands, locked the bedroom door to prevent officers from placing him in custody. Based on all of this, the officers are requesting a high bond as well.
I have 2 violent misdemeanors, 12 misdemeanors, 0 failures to appear. The officers, as the state said, did make a bond recommendation for request for a high bond based on the allegations. Is he executing the TPM?
Yes, Your Honor, he's already signed.
On the strangulation, 10,000 straight plus EMD plus juris if requested. On the felonious assault, is that the knife?
Yes, Judge, I believe it is.
50,000. Secured. Plus juris if requested. On the menacing, 1,000 anyway, plus juris if requested. On the act menacing, 5,000 anyway, plus juris if requested. On the resisting, 2,500 anyway. On the domestic violence. It's charged as a misdemeanor, but based on the record that I have, it technically would be a felony, but it's charged as a misdemeanor right now. 10,000 anyway, plus juris if requested.
Judge, grand jury date will be 11/7.
Sign, sir. So hold right,
Horns, Jacqueline Horns.
One.
These are mine, and these are Pete's.
Okay.
Good morning, Your Honor. We will waive probable cause.
All right, as to bond.
As to bond, we are asking for an OR, Your Honor. Regarding this allegation, Ms. Horns, she did speak to our social worker. She is currently receiving methadone every single day, Your Honor. She's currently actively in treatment. We spoke to her about the possibility of inpatient treatment, and she said that's something that she's interested in. So we're going to work to get her connected with First Step Home, because that's a facility that could take her as well as her daughter, Your Honor. Right now, she is living with her grandmother, and she takes care of her grandmother and her daughter. Her daughter's 3, her grandmother is in her 80s, so she is primarily the caretaker for both of them, Your Honor. Apart from that, Ms. Horns doesn't really have a record. She does have her GED. She did briefly attend a Southern New Hampshire university, but she had to drop out in order to take care of her daughter, Your Honor.
How old is her?
3. And like I said, we are asking for an OR, Your Honor, or a supervised OR, Your Honor. I think the biggest priority right now is to be able to get Ms. Horns set up with treatment, Your Honor. So that's what we'd be asking for to start that facilitation.
From the state.
Your Honor, the felony is an F3. It occurred the discovery of drugs, cocaine during intake at the Justice Center. She also, I believe, had paraphernalia earlier, and then she apparently furnished false information. She gave, I think, her sister's name or somebody else's name, which kind of led to this. It's a little, I guess, confusing because the complaint for the ticket with her name on it shows an offense of 9/8, but she wasn't served with that ticket until yesterday when she was picked up and they discovered that she had given that name. At least that's the understanding of the state at this time. So the felony and the possession of drug paraphernalia and the traffic case ending in 27748 will all go to the grand jury, and then the rest will go to the assignment commission.
Did you want to add anything?
Your Honor, we would just enter a not guilty plea on the 2015 and 2017 cases. Those are unrelated to anything that has been addressed. Submit based upon what felony counsel has stated. I would just add that she is engaged in behavioral health over in Milford. She is actively getting medication there for some anxiety, chronic PTSD, and other issues there. So we would ask for the OR or the supervised OR bond, so that way she could continue on with the treatment, become reconnected with our social work division, and we can go through this that way.
On the traffic cases, the driving under suspension, speeding, failure to maintain reasonable control, those are all OR bonds. On the furnishing false information, illegal conveyance, possession of drug paraphernalia, and the habeas bonds, well, the new cases, the bonds are 1,000 anyway, or alternative OR EMD lockdown to First Step Home. Defendant shall be transported to First Step Home only by a representative from First Step Home. They do come in transport. The jail or a representative from the PD's office if a social worker takes her. But it will be EMD lockdown. The child is 3, so there shouldn't be an issue with school, because you do have to take your own kids to school at First Step. But child is 3, so that should not be an issue. The other cases, it's the same bond, which the habeas bonds were 2,000 on those, or alternative OR EMD with the same stipulations, locked down at the treatment facility.
Grand jury will be 11-7. 11-7.
Only on,
Only on 022. 020. And the traffic ending is 7.
How much? 748, okay. So 61 and 62 go.
Everything else will go to the AC.
Okay. Thank you.
George Hopper.
And what was that date again? I'm sorry.
It's 11-7.
Thank you.
Are you on this case, ma'am? I'm sorry, he's speaking to the box?
It's my son.
Okay.
Jamila Bash on behalf of Mr. Hopper, Judge, we will waive probable cause and ask to be heard on bond this morning.
Yes, that's the bond.
As the bond, Your Honor, Mr. Hopper is 22 years old, Judge. He has no adult record, none whatsoever, 0 failures to appear. I do understand his risk assessment score is 3. Part of that is because he recently moved in with his uncle. That is where the place of arrest was actually outside of the home, Forest Avenue in Norwood. That is also the address that pretrial confirmed for him. This was technically not a traffic stop. He was outside the home, inside of a car that was not running, that wasn't driving or anything, Judge. I do understand that his disability is based on a juvenile adjudication. Judge, he does work. He works with his family business, with the family business. Harper Construction is actually something that he's been doing since he's been 12 years old. He also has an interview set up Friday for a second job. Judge, his mother and his sisters are here this morning supporting him. He has strong family ties to the area. Judge, he's also assumed to be fathered. He has a baby boy due in December. Judge, we are asking the court to consider OREMD. I do understand these are weapons charges. However, Mr. Hopper has no record, none whatsoever. I did speak with his mother this morning, and she has confirmed that if the court is inclined to impose that bond, that he can stay at her home. I explained the conditions of EMU to Mr. Hopper and his mother. They both understand those conditions, and as I said, his mother is more than welcome to allow him to stay in the home while on EMU.
Your Honor, it appears he is under a disability from the juvenile court case 22-2266. That's an attempt. I think the court is aware of that as well. It appears that the officers came to that area for a report of 2 males in a sedan. We've been sitting there for the last several hours. He spotted the blue sedan, and then the officers also noted that they observed a handgun on the hip of the defendant. He went to the passenger side of the vehicle at the time that he arrived, made contact with Mr. Hopper, opened up door and asked if he had a firearm on him. He did, and it was on his hip. So kind of it was pretty open and obvious that he had that. Looks like his disabling offense, he admitted to that in January of 23 and was terminated from that in March of 24.
As an adult, Mr. Hopper has no records, no failure to appear, but because of his age and the time frame in which the juvenile court case occurred, there is one violent felony as a juvenile that is 2 years, only 2 years removed. On the weapons under disability, 5,000 secure plus EMD, the CCW 1,000 anyway, or alternative OR EMD on the improper handling 1,000 anyway, or alternative OR EMD.
Will the court consider 10% on the A charge? The family thinks they can post the most at 600.
I will not modify that because the disabling event was less than, or was about 2 years ago, and he just got off probation for it. It's not far removed. Edward?
It's a grand jury day.
Grand jury will be 11/7.
Warrant.
Quarters and short recess. Thank you.
A lot of guns, huh?
Oh, my goodness.
Right, that's all it is.
The same height, same right. Yes. They noted it was coming up.
And what do you do?
Like I said, on the 2 block. Yeah. Is Ariana Ward in court? Ariana Ward?
No, it's okay. Yes, a series.
Yeah,
He's
where'd
got
you
a
go?
couple of convictions. He's got both convictions and dismissal. So I'm assuming she can.
Yeah. His prior was the same victim from last year.
Right, because he's got a couple of earlier ones that were dismissed.
Yeah.
You said.
You have the paper I can write on. Just a blank.
What do you want?
Well, you know, I'm thinking about just from a church perspective. Like,
What's that?
I'm just thinking about from a church perspective as a pastor, what we can do within our congregation with the young people. Those DV cases were so interesting.
You know, most of the
His
things.
current students, no license, no accident.
And then I thought it was interesting what the judge said that when there is a no contact, they can turn into additional charges. And many times if that person calls the person that they're supposed to stay with.
Well, yeah, because while the no contact is a condition of bond, so they can violate their bond. If they actually issue a TPO, they can file new charges. So if a stay away order, that's just a condition of bond. So they would violate the bond, not necessarily pick up a new charge. You know what I mean?
Yes.
Where if you violate a TPO, you get a TPO violation, you get a new charge.
What is the, is it an emergency a mandatory evaluation? What's the
EMD.
EMD.
It's home incarceration. Put a box on you until you step
Gotcha. Okay.
And then choice monitors for a victim of like a DV or something. It's like a cell phone. And then they wear a box and then they get an exclusion zone. that notifies.
Your Honor, we would
the
waive
person
probable
of the cell phone
cause.
that notifies the-
There is a request for protective order which he is executing. Just to apparently solve some confusion, the complaints for the C and the D and the complaint for the E and the F respectively read almost identically. And apparently there are alleged 2 separate firearms, not one firearm. I just wanted, that's my understanding of what the situation is.
So it was same
Same
incident,
events.
2 different.
Right, but 2 different weapons that are described the same way.
They're just both described, Your Honor, as Glock 43Xs. So 2 of the same kind of handgun is what I'm seeing in the police investigative notes.
Your Honor, he denies the allegations, but we can obviously deal with that in the future. With respect to bond, these occurred on October the 6th. He turned himself in on these charges. His mother told him that he had open charges, and he turned himself in yesterday. He would stay with his mom in Mount Auburn if he's able to get out. He is apparently on probation at this point. He thinks he's almost done with that. He was hoping to get that finished up soon. He's 26 years old, longtime resident of Hamilton County, and he will abide by the TPO and stay away from the protected parties. He does not reside with the protected parties.
Your Honor, concerns, I will start by noting that the police are requesting a high bond in this case. The allegations as it relates to the domestic violence is that he pointed a weapon, a gun, at the victim, and while she was holding a infant child, her infant child, the threats then were that he was going to shoot them. Officers observed him with a green backpack or satchel, placed that on a porch and then fled. They recovered that, and that's where they recovered the gun. So they saw them in his possession, or the backpack where the guns were found in his possession. It does appear that he's on probation, possibly to Judge Branch, for strangulation. I would note that his prior DV is from last year with the same victim. The allegations include that he struck the victim in the face. Officers did observe injuries. So we are very concerned about the safety of the victim, very concerned about the safety of the public in this case. We will join with police in requesting a high bond, and we would also request END and juris if requested by the victim. We would additionally note that he is under a disability and that the strangulation qualifies as a violent felony, as well as any prior disabling offenses, and stay away, no contact with the property owner as well on the RSPs. And he is under disability, however, we request no firearms as a condition of bond for this case.
Did he execute the TPO?
He did.
On the domestic violence charges, A and B, the having weapons under disabilities, C, well, go back to here. The A and B domestic violence, 25,000 secured each count, plus juris if requested. Having weapons under 25,000 secured on each count. The receiving stolen properties, 15,000 anyway on the other counts. There is 1 violent felony, 1 felony, 2 violent misdemeanors, 10 misdemeanors, 8 prior failures to appear, and current probation on an act of violence.
Our grand jury report will be 11/7.
Is that on everything?
Yes.
Thank you.
In a bit.
Good morning, Your Honor, again. We will waive probable cause. As to bond for Mr. Inabnet, first and foremost, Your Honor, I do want to point out that Mr. Inabnet he works full-time. He actually has a very interesting job. He works for RTF Fire Protection. He's been working there since January. He helps install like the fire sprinkler lines in buildings. So it's the first I've heard of it, but I thought that was very interesting. He works full-time, been working there since then. This is a low-level nonviolent felony. He's from Cincinnati. He has his GED. He is receiving mental health services as well, Your Honor. He's on mental health medication that he received from University of Cincinnati. So he does have mental health diagnoses. He was actually set to start at Spring Grove, the Talbert House residential sober living this upcoming Monday, Your Honor. So he was set to do that. What we're asking for is an OR or a supervised OR bond, Your Honor, so that way he can start that program. And like I said, that way he's also able to maintain working. He's actually set to work today and he's missing work being here.
From the state.
Your Honor, I know the court has reviewed and is aware of his prior record. I would note that among the allegations, he did admit he took the vehicle.
Is this allegation a known party or unknown person? Does it have any indication?
It looks like on the 527, it's claiming a known subject. So
Yeah.
You said no?
yes, Your Honor. I think this might be a borrowing car situation.
That was my impression.
I'm sorry,
That was my impression, Judge.
that it was a,
It was a known person.
in what facility was Mr. Inabnet supposed to be going
The
to?
Spring Grove Talbert House.
Which program is that?
The Talbert House, it's like I think it's it's like a residential Talbert House program off of Spring Grove. So I don't believe it's locked in because you should be able to go to work from there. But it is a treatment program off of Spring Grove. I've had quite a few clients actually go there.
There's 4 violent felonies, 8 felonies, no violent misdemeanors, 5 misdemeanors, 0 failures to appear, 1 pending charge. Looks like it's a minor misdemeanor. And it appears the parties know one another. OR plus EMD to the Spring Grove Talbert House facility. Defendant may have time out for work.
Judge, the grand jury report date will be 11/7.
Thank you.
Thank you, Your Honor.
Jacobs.
Morning, Judge. On behalf of Mr. Jacobs, we would waive probable cause. I note there are 3 different case numbers, a total of 4 judges' sheets. I believe they all stay together at this point. The most serious charge is the failure to comply. He tells me that was an extremely short chase. if chase is the right term, but he did not drive for any extended period of time. And when he got out of the car and realized the officers were looking for him, he stopped and was taken into custody. He lives in Winton Terrace with his cousin. His cousin had a stroke or similar medical condition. He's in a wheelchair. He's basically paralyzed on the left side. And so he takes care of his cousin. He's working right now. He thinks he can post about $1,000. I would ask for the court to set that as the bond limit. And if they're to comply, no other remaining charges. That's the only felony, is the failure to comply.
From the state.
Because the failure to comply, the obstruction, and the traffic will all go to grand jury. It appears that the high rate of speed is what probably elevated the failure to comply charge. I would note that it does appear that he has contacts in Kentucky for robbery and burglary, although it doesn't give me a disposition. It says it's listed as no dispo. And he said, basically after he turned down a dead-end street, he bailed from the car and was apprehended a short time later.
So short, high-speed chase as what was described ended on a dead-end street. And then the allegations led on foot. Does it say how far the stop was or the chase was? The car, not the.
I'm trying to look on a 527 to see if there's a location of offense or location. So, the location of the offense is listed at 5200 Winnesty, and then 3827 Esty Avenue is the location of the arrest. So that, I believe, is less than a mile.
And Judge, the 527 eventually says that officers were able to eventually apprehend Mr. Jacobs without incident. So there was no struggle or anything like that.
That's correct.
There's no bond preference.
That's what also I'm showing is listed. Let me check the other.
That's what the bond, my bond chief indicates.
There's one felony, one misdemeanor, one prior failure to appear. 1,000 anyway on the obstruction, the driving without a license, OR, the leaving the curb, OR, the failure to comply, which is a felony of the 4th degree, fleeing and eluding a police officer. $25,000 anyway. Plus EMD.
Judge, 11-7 for grand jury.
Thank you. Jinx.
Please hold, Your Honor.
No, that goes to grand jury.
2600.
No, the whole stack.
No, that's the 10%. That's the 2%. This is so does he know about that? Your Honor, on behalf of Mr. Jinks, we waive probable cause on the felony charges.
That's the bond.
If I can have just 1 second. Now,
Is there?
Your Honor, there's, I believe, a holder for Kentucky.
Okay.
There are two misdemeanor charges that go with the felonies that I believe that group goes together, the 19048, the 19049, and the traffic 27749. All go to grand jury.
That's correct.
There are some other misdemeanors that do not.
I have a case ending in 8660.
Yes, I believe those are the unrelated misdemeanors from 2023.
Judge, with respect to Bond, he is employed doing HVAC studies at Fortis. He also works as an assembler in a factory. He lives in Walnut Hills with his mother. As I said, he does have a holder for Boone County, which will have to be resolved. We would ask for a nominal bond.
Judge, we'd also be asking for a nominal bond on the misdemeanors.
So I don't change bonds of the trial judge unless there's a good reason to. So I will keep Judge Mallory's trial bonds on the 23 cases from the state on the new cases.
Judge, I would note that the officers are requesting a high bond in this case. Several open warrants. They listed crack on his person over.
Is there a weight on the drugs?
It's charged as an F5, so it's.
But is there a weight on the charging document?
There's not a weight on the charging document. I'm probably still waiting for the lab to get back. So that would, by virtue of that, make it a F5 in the absence of any weight. But the officers also note that he had several open warrants, which we've already noted, the crack. And then it looks like he's got pending charges. And then he has a history of failing to appear, which I think is, I'm showing 2. I don't know if the court has another case.
2 violent felonies, 2 felonies, no violent misdemeanors, 3 misdemeanors, 3 prior failures to appear. Is what I have.
So we are obviously concerned about that. And it looks as if during the chase, officers necessitated them deploying a STAR chase device, which is a device that attaches to the vehicle and they can track it so they don't put themselves or the public at risk by continuing a chase. He did jump out of the car as it was rolling and then ran from police. They had to use a taser to take him into custody. So for those reasons, and obviously the contacts or the warrants out of the Commonwealth do show a prior failure to comply from May of 2023.
So I understand that the defense said that they waived probable cause, but the charging document is blatant. There is no weight. It just says crack cocaine, gram weight. This court is not going to guess what the weight is. That is not the job of this court. The charging document on its face does not have the weight. So I'm finding that there's on the A, no probable cause to hold. On the rest of them, yes. So because there is not probable cause on the drugs, that is an OR. They have gram weight, but did not fill in the number for what the actual weight was. On the failure to comply, it appears that this is, there, as the state pointed out, there was one in 2023, so this allegation is a second. 15,000 secured, the driving under suspension, OR, disobeying traffic control devices, that's under the city code. Is that a minor misdemeanor?
I think it's a minor misdemeanor, yes.
OR on the obstruction. $5,000 secured.
Your Honor, grand jury report date will be 11/7.
Is that on everything?
That is on everything.
Thank you.
Thank you, Judge.
The 23 case, the 23 case decision.
The 23.
23 case, yeah. The case, that just goes back to the AC.
Okay.
Jonathan Johnson?
Good morning, Your Honor. Aaron Levinson on behalf of Mr. Johnson, under a plea of not guilty, waived probable cause. This is the co-defendant to the other marijuana case you had where you gave that individual an OR bond. We are also requesting an OR bond in this case. There's not an amount of marijuana listed in this amount, but I don't think it is particularly significant. It is an F5 at this moment. We'd ask for an OR bond.
Nothing additional, Judge.
Say that this is the F5 trafficking, no weight on the drugs, OR.
Thank you, Your Honor.
Is that the 12th day?
Judge, Mr. Johnson also had traffic, those are the OR as well.
Okay.
The grand jury will be 11/12.
Is that on everything?
Yes.
Okay.
Ryan Lindsay.
Child comment.
Is a request for an order of protection. Michaela Mack.
Go hold it.
Go hold it.
Your Honor, this was warrant service, so we'll waive probable cause. Thank you, Your Honor. As to bond, to cut to the chase, Your Honor, Mr. Lindsay does have a probation violation holder that's going to hold him at least until we can get in front of the felony judge. I would note, I am going to ask for nominal bonds. Mr. Lindsay is 22 years old. He has 0 failures to appear in the last 5 years. He does have a good job. He works at Dash Construction. He has his high school diploma. He graduated from Lake Grove High School. He adamantly denies these allegations, and we intend to fight them, but he has executed the protection order in the meantime and understands he cannot have any contact with his prosecuting witness. He does not want to have any contact with his prosecuting witness. It looks like this was a desk report made allegedly the day after this was supposed to have occurred. Ultimately, Your Honor, I'm just asking for nominal bonds on these matters.
From the state.
Judge, it looks as if he dragged Vicky through a parking lot, causing her, by her hair, causing her injury to the face and shoulder. You note his previous record. He strangled her. She does indicate that she did not lose consciousness during the incident. We would request monetary bond, EMD and juris if requested. TPOs in force, so there will be no firearms over for that.
And looks like Mr. Lindsay has 4 felonies trafficking in marijuana from several years ago. There is no other record, no failures to appear, nothing of violence. But the nominal bond as requested by the defense, 1,000 anyway, plus juris if requested with the TPO.
Your Honor, grand jury would be 11-7 to both, 11-7.
Your Honor, is that on each, sorry.
Sign, sir.
Eric Morgan.
Thank you.
Thank you.
Good morning, Your Honor.
What probable cause?
Your Honor, we'll waive probable cause as to the 2 drug charges, the weapons charge. We'd like to hear probable cause.
Probable cause on the weapons.
Yes, Judge, it appears that yesterday, 10/28/25, he did knowingly have a, defendant did knowingly have a Sky CPX 1 9mm handgun between his seat and the center console. Officers located the firearm during a probable cause search. What appears to have happened is that they made a traffic stop and brought in a canine who alerted on the vehicle. They then searched the vehicle.
Your Honor, this was not his car, and it was not his gun. It was his wife's gun and his wife's car. Yes, he was driving. She's here, and I think would like to verify that. She's here, and I think she would like to verify that information for you.
Yes, I verified to the officer last night that pulled us over several times that the vehicle is registered to me and also the firearm is registered to me.
Thank you.
I was just getting off of work, doing a 12-hour shift. We was going to get something to eat. We pulled over and that's when he took over driving.
You all were in the car together?
Yes, ma'am.
Okay. Thank you, ma'am. Anything else?
Nothing on that point, Your Honor.
On the drug charges?
Again, we're waiving probable cause as to those. As far as bond goes, he's 49 years old, a risk assessment score of 3. He does have 1 failure to appear that I believe was on a traffic charge. Otherwise, his record is quite old. He lives in Cumminsville with his wife, has an associate's degree in criminal justice. He works at Performance Food Group in their warehouse as a forklift operator. Your Honor, I'm going to suggest to you he's a good candidate for an OR bond.
From the state?
Judge, in this case, the officers do put a weight range between 5 and 10 grams on the cocaine. What is concerning is that you have drugs and weapons together in very close proximity inside the vehicle. Looking at his prior history, he does have prior history for trafficking in cocaine. And where the weapon is described as being located is pretty open and obvious because it was between his seat and the center. So in very close proximity to his right leg. So there certainly would be at least reasonably an awareness of the weapon in the vehicle. much of that probably for later on. However, we would ask that appropriate monetary bond be set and no firearms.
There is 1 violent felony, 8 felonies, 7 misdemeanors, 1 prior failure to appear. The drugs, are they charged in the alternative?
Judge, the possession and trafficking, those would merge.
Judge, we have a suspicion that it will come out in F5 from the grand jury. We don't think it was much over 5 grams, and we suspect that the weight is, shall we say, slightly exaggerated at this point. Obviously, the grand jury will clear that up.
Make him eligible for OR, EMD on those.
On all 3, Your Honor?
I still haven't made a probable cause determination on the having weapons while under disability.
Your Honor, since the result of that would be an OR bond, we're glad to, at this point, waive it if you're interested in just making it OR without a formal determination.
I want to do that. The court's issue is going to be an OR, either if there was or wasn't probable cause. Witness is here saying it is hers, but the other issue is that the charging document does not mention any disability at all. It just says what the gun is. So I have his record to see, but the charging document itself doesn't say a disability from X or what have you. It just has, there's a gun in the center console of the seat. All right.
Do we have a date?
I have a return.
Court is in a short.
Grand jury will be 11/7.
You want to do it that soon on OR?
It's at 11/7 because it's an EMD, OR EMD.
Oh, okay.
Yeah, so if it has any kind of
Yeah,
additional
you don't
attached,
I'm not, yeah, I just wanted to make sure.
I gotta do the end date.
Okay.
Because he may not get out today on the end date. He probably will. We don't want to.
Yeah, well, if there's juries monitor, it's a different issue.
No.
Robertson.
It's not the same address, sorry.
Robertson?
Good morning again, Your Honor.
Good morning.
I've discussed this matter with Mr. Robertson, and with the court's permission, we'll waive the hearings to probable cause.
All right. Yes, Yvonne.
Your Honor, he's 39 years old with a risk assessment score of just 3. He has no history of failing to appear despite some opportunities to do so, though none of them. He has never had a violent offense on his record. The police indicated no preference as to bond. He lives in the West End with the mother of his children. And I assume with the children too. I didn't ask that part, but the children live with you too? He went as far as 10th grade in high school. He tells me he's literate. He works at Anchor Fluid Power, working in their warehouse as a packer. Your Honor, there's no allegation that this weapon was in any way used, which suggests to me that it was being carried for defensive purposes. And I would suggest to you that no, our bond is appropriate.
From the state.
Unfortunately, the issue is, it's like we have possession of cocaine and prior weapons under disability from 2024.
A conviction for that?
Yes, from Judge Gehring. It looks like he served a term of 24 months in the institution as a result of that. So he would have recently been, or somewhat recently been released from that. In this particular instance, he had the gun in his sweatshirt pocket, and he did admit to the police to possessing a firearm.
Mr. Robertson has 13 felonies, 3 misdemeanors, 0 failures to appear. It looks like he was just released from the penitentiary July of 2025 on drug trafficking and weapons under disability. On the CCW, 10,000 secured. On the having weapons under disability, 25,000 secured.
I'm sorry.
25,000 secured on the weapons under, 10 on the CCW.
11-7 for grand jury.
Thank you, Your Honor.
Thanks.
So
Jamila
you got a
Robertson.
$35,000. You can go to a bondsman, you can post the full 35,000. You can do a real estate, it always has the, people can't do that. Okay? So $35,000 bond. A bondsman will cost you about $30,000.
Robinson.
Let's move up. Robinson's the next one.
These will go to the grand, they're out of the same incident, so they'll both go.
Thank you.
Verdict for Jamila. Ben Ransford, Jamila Robinson, Your Honor. I would like to hear probable cause with regard to the stopping after.
Yes, that on September 4th, 2025, in Hamilton County, State of Ohio, being the operator of the motor vehicle, he was involved in a collision with a person on a public roadway, and having knowledge of that collision, failed to immediately stop that motor vehicle in which that collision resulted in a serious physical harm to another. The complaint indicates that in the video surveillance, the defendant in the driver's seat operating the vehicle, when the victim was struck. The defendant was on EMU, also places her at the La Rosa's restaurant at the time of the offense, and she was identified as the co-defendant in the subsequent interview. The co-defendant identified the defendant as the operator of the vehicle, struck and seriously injured.
Your Honor, the police report indicates that the injury here was a laceration that was treated with a paper towel and a potential concussion. Do not think that rises to the level of serious physical harm. As such, I do not think there's a reason for this to be a felony. I'd ask for no finding of probable cause.
The court will find probable cause.
Esteban, Your Honor, she has 0 convictions as an adult. I see 2 convictions as a juvenile. She's 26 years old now. She lives in her apartment by herself in Westwood. I do have good contact information for her and her mother. Your Honor, she's very concerned about her service dog, Gracie. She has a seizure condition that Gracie helps her with. When she was arrested yesterday, she did leave enough food for yesterday and today. Tomorrow would be a big problem. She's already out on EMU with some misdemeanor charges. I spoke with her misdemeanor attorney, Jesse Jackson. He said he's had outstanding communication with Ms. Robinson. And so we are asking for an OR with EMD bond so that she can get home and care for her service animal. I will also say, Your Honor, she isn't working right now, but she is engaged with GCB for the last month. She went to GCB to try to get some of her issues taken care of. And so they're working on getting her SSI. So this allegedly occurred September 4th. As far as her failures to appear, I see 2 per the pretrial paperwork. But like I said, and she was at court as recently as last week with Mr. Jackson and has another court date on the 10th. I do believe those failures to appear would be related to traffic matters. I don't see any adult convictions. I'll submit on that, Judge.
From the state.
Judge, it looks like this all arose out of a theft offense that accompanies the failure to stop at the Roses on that day. And basically they did not pay for the food that they got. Someone from the Roses comes out of the parking lot to confront them, and that's when he is struck by a car. I would note that her record in 2022 showing an OVI, endangering children, and improperly handling firearms in the motor vehicle. That list says no dispo, so I'm not sure what the outcome of that was. It does also indicate a open aggravated menacing and aggravated trespassing case that's noted in front of Judge Johnson. So we're concerned about this continuing kind of behavior, the fact that she was on EMD at the time.
On the theft of our EMD, on the failure to stop 10,000 anyway.
Your Honor, she's indicated to me that the family can make about $200. Would you consider a $2,000 bond?
I will not with the actual person being hit instead of a car.
Your Honor, it appears she's not charged with any kind of aggravated that this person ran into the road.
I understand what the allegation is. I'm not changing the bond.
Understood, Judge.
Sims.
11-7 for grand jury for both. 11-7.
Thank you.
Let's talk about the number.
So A is Ms. Lees. Do you have Sims?
Oh, yeah, she is Sims. You have Burr.
Okay. This is, sorry. I don't know if you want to do what I just said. That should
It's separate from.
yeah, it's not with felony.
All right, have you all worked something out on the traffic? or-
TRD case 12170, I'm expecting to guilty on the A. It's an unclassified suspension for this purpose, and then asking you to dismiss the improper legs.
Mr. Sims, a guilty plea is a complete admission of guilt. This is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 and fines and costs up to 500 hours of community service. You do have the right to a trial. Knowing the right to trial, the maximum possible penalties, do you want to maintain a guilty plea to an unclassified driving under suspension?
Yes.
Counselor, do you waive the stipulation?
Yes.
Finding of guilty, Mr. Sims has been in for one night.
Yes.
Is there anything else in mitigation?
No, we just asked to correct the
Anything from the state?
No, Your Honor. No insurance.
One, credit one, remit the fines and costs. Mr. Sims, did you want to say anything? You have the right to, you don't have to. What do you have to do to get your license back? No?
Just pay some fees. That's it.
All right. If you have any questions about it, when you are released, go to room 167 in the courthouse. They will tell you what you need to do. They will also let you know if you qualify for a payment plan so that you can get driving privileges to go back and forth to work. All right? All right. As to the felony,
Your Honor, I've discussed this matter with Mr. Sims, and with the court's permission, we'll waive a hearing as the probable cause.
as to bond.
Your Honor, he's 31 years old with a risk assessment score of 6. He lives in Bond Hill, graduate of Don High School. He may be Don's proudest alumnus at this point with what's left of Don. He has no violent record. I believe the alleged disability here comes from a drug offense of the last decade. I will suggest to you, Judge, that there's no indication this weapon was used in any offensive manner and was being carried for defensive purposes.
From the state.
Judge, it appears that his disabling offense, as noted in the complaint, is a trafficking in cocaine from 2019. Additionally, he does have prior weapons charges. It looks like at least 3. In this particular instance, he was observed jaywalking. Officers attempted to stop. He pulled away and fled on foot. Officers caught up with him. Again, eventually deployed tasers, and then he was arrested without further incident. The firearm was recovered from his jacket pocket, and in fact, that it's a weapons-involved case, and he did run with the firearm from police, which kind of elevates the danger factor, and has prior weapons charges and the prior drug trafficking offense. They are requesting a high bond.
What's the prior weapons?
Judge, going back, looking at, it's got CCW in front of Judge Metz, B137236, and then another one in front of Judge Metz, B143814, and then one in front of Judge Lubers.
I'm seeing them. I hadn't gone that far back from 2013 and 14. All right. There are 4 prior felonies, 2 misdemeanors, 7 prior failures to appear on the obstruction. Keep the standard bond of $1,000 anyway. On the having weapons under disability, $5,000 secured plus EMD.
11-7.
Are all 3 charges, including the jaywalking, to go to the grand jury?
Yes.
These two, it's odd. It's with the same incident. It's under a CRB.
It's under what?
CRB case number.
The
I don't have a jaywalking.
Pedestrian violation.
pedestrian violation, it's the B charge on the
Oh, I see.
4-0.
Okay.
So that one is the one too?
Yeah, everything's going.
All right. Sherry Stain.
I'm putting Terry Tranner's designation.
Drug court case.
Yes, Judge.
Judge, it appears, these are from 2024, cocaine and fentanyl, both F5s. And the misdemeanor will go with the felony.
We'll waive probable cause, Your Honor.
All right. Is there anything else from the state as to a bond request?
No, Your Honor.
These are drug possessions, drug court eligible from a year ago, supervised or.
That will be 11-12.
Thank you.
11-12 for the jury.
Thank you, Your Honor.
Thank you.
Now we are on to the walk-ins. When you hear your name called, please come to the door. The deputy will let you in. Zachary Prairie. Daryl Jackson.
Yes.
Kayvon Whitfield.
Yes, I have them all.
You have the complaint, well, I think it was Prairie was the one they gave you last.
Prairie's the first one.
Your Honor, this is Mr. Crary.
All right, so last night the court set an OR bond. Mr. Prairie is here. The court set an OR bond yesterday because what was conveyed during the bond setting was that there was no allegation of what actual drug it is suspected of being. It's a white powder in a receipt with no allegation of an actual drug.
Judge, I would just note the complaint does indicate heroin. Mr. Perry?
Where?
Third line down.
Thank you.
Which I actually read right over that myself.
Yeah, I asked them to read it to me last night multiple times, and I guess they just sent me this affidavit. Well, that makes better sense now. So you're waiving probable cause?
Yes, Judge, and we
It's-
appreciate the OR bond and hope that remains in place.
Is there anything from the state
No,
here?
Your Honor, 1112 is grand jury.
Supervised or? All right, thank you.
Oh.
What is this?
You can go up that.
Harold Jackson?
Good morning, Mr. Jackson.
No worries.
Waive probable cause.
Your Honor, yes, since he's got an OR bond, you will waive probable cause.
All right, is there anything from the state? I said
Judge.
OR bonds yesterday. It looks like this is a first ever OBI.
Yes, Judge, the first ever OBI, there is an ALS in place. It looks like the test was .184, insurance was shown. And
Accident. No.
there was no accident. The only concern in the state at this point is that, as a condition of bond, is that no firearms because we have alcohol and firearms together.
Your Honor, if I
Mr.
could.
Jackson does not have any offense that would disqualify him from legally owning a firearm. The having it in the vehicle, the court is not going to order basically to disable him from having a firearm based on the pending charge. It'll be OR putting the firearms restriction on.
Your Honor, could I have a moment to ask a question of the prosecutor before we move on? The complaint reads like a firearm while intoxicated charge that got filed under the wrong section. There's no indication he's not an
They'll take care
eligible
of that.
adult.
They'll take care of that over there.
You don't want to do that today. Your Honor, a couple other things, if I may, real quickly. The citation on the DUIs, the OVIs, I'm gonna get it right, says that he's scheduled for court on October 31st. I just want to make sure that's not an active date.
What does it, is there something on the
Can we
jacket?
grab those jackets back? Please?
Jacket on Jackson?
And we had a jacket for Jackson. Yeah.
Which document has it?
The MUT judge.
It's the OVIs, the traffic, the ticket at the top shows 1031.
Okay, 1031 at 12:30.
I just want to make sure that there's not going to be a capias issued in error.
Vacate 10/31/25. Date, that is at 12:30 PM. REC.
And Your Honor, one more thing, if I may. I realize there is a hard suspension on these charges. He does work as a truck driver for Furniture Fair. This offense did not occur while he was working. It was a personal car. I'm wondering if the court would authorize privileges for after the hard suspension time expires.
You would have to take that up.
It should go to the trial judge.
Okay, but we're sending this to the grand jury, so we don't.
1112. It's grand jury day.
The OBI is here with it.
Prairie?
The OBI is a felony.
Yes.
So at this time, you are not authorizing privileges once the hard suspension expires, is that correct?
This
When is he,
not a CRB,
what
it's
is
a
the
CRA.
date for the, alert?
It's a felony.
With, 10:39.
No.
It's very
Or no, I'm sorry.
What's the very?
This CRB.
He said 11:12.
11:12.
11:12. So yeah, both good.
Thank you.
So
No, I won't order them at this time, but the 15 days will be right when he comes back for the grand jury report, so he can settle at that time.
thank you, Your Honor.
Thank you. Whitfield. Good morning, Mr. Whitfield.
Also the OR bond.
All right.
Mr. Whitfield.
All right, Mr. Whitfield, waive probable cause.
Yes, Judge, I submitted Timothy Bicknell's designation.
All right, and Mr. Whitfield got an OR bond yesterday, showed up today. Is there anything from the state?
Just 11:12 grand jury.
All right, OR bond.
Judge, that is your
Thank
felony
you, Your Honor.
docket. On to the county license.
Joe Armstrong.
Right.
He is not.
Esteban.
As to bond, Mr. Armstrong has a good Cincinnati address. I have good numbers for both him and connections in the city. He receives a social security check every month. He's a graduate of Hughes High School, or 11th grade Hughes High School, lived in Cincinnati his whole life. One of the main reasons Mr. Armstrong needs to get out of jail today is because he has cancer. He is currently suffering and wants to get treatment, wants to continue his treatment, and make sure his body is right while this is going on. I believe this is, in reading the complaint, an allegation of a repo kind of gone wrong. I think there's facial issues with the complaint of the failure to comply. I don't think it ever states that an officer made it any sort of order. It says the defendant failing to allow a tow truck driver to repo his vehicle. As to the other ones, he's had no convictions since 2007 with 0 failures to appear. I believe he will come to court while undergoing his cancer treatment. We are just asking for a supervised OR today.
All right, are you on this case?
We can't, sir, we can't hear you. You have to come up and
He
speak
raised
to the
his hand. I
box.
thought he was on the case. If he's not on the case, then I'm not.
I have a felony, you said felony docket was clear.
What?
I have a felony, and you said the felony docket was clear.
Yes, so when the docket is over, the deputies will come talk to you, okay? Thank you.
Yeah, I was gonna say, he's
Oh,
probably
it's
10,
10:30.
he's probably a grand jury report.
All right. Anything from the state?
No, Your Honor.
Do you have anything that on the failure to comply, that there's an officer that was there?
Judge, I do show that officers were called out to the scene. And as counsel noted, it looks like when they arrived at the scene, he was in the vehicle and they ordered him out of the vehicle, which he didn't comply with initially. He eventually did get out of the vehicle. So I think that's what we're getting, the failure to comply.
Supervised O'Rourke.
Thank you, Judge.
Bohannon.
The plea is not guilty.
Esteban.
Esteban, I've submitted designations for Corbin Ines. He is already representing Ms. Bohannon in court tomorrow. She knew her court date. She's planning on being there tomorrow. We know that she knows the importance of getting to court. I think most important on these charges, you've already seen, I believe, the cross complainant in this case. This all stems out of the same incident. And as you can see,
Cross complaint?
yes, I believe.
Who?
Not yet. Oh, I'm sorry. It
Who's the
must be.
cross complaint?
I think it's not necessarily a cross complaint. Our private witness is a Keisha Parker. That is the mother of someone else who's been charged with domestic violence against Miss Bohannon.
Curly. Okay. Is that the prosecuting witness here?
Judge, I'm showing Keisha Parker, and in this case, it seems to involve her property and both real property and tangible items.
And how is Parker and
Parker's the mother, I believe, of the the person charged with domestic violence against my client.
okay.
So I think this all stems from the same incident. They have charged her with throwing a grill. She adamantly denies that. She was thrown into a grill. As you can see, she has serious injuries on her face, her lip, some serious injuries on her left side right here, significant bruising. I think she probably needs to go see a hospital, maybe for that eye. I have good contact information with her sister. Corbin has had great contact with her, staying in the process of court. She's for trial tomorrow. We're asking for a supervised order.
From the state?
Judge, it does appear that she has pending theft case and a number of, well, at least one prior from June criminal trespass. I don't know if it, prior theft cases as well. Just wanted the court to make note of that.
Supervised O'Rourke. She has 3 misdemeanors, 2 prior failures to appear. This is an M4 and an M2. Berg. Timothy Berg.
This is okay. Yes. Judge, it appears that the traffic matter is unrelated to the criminal matter. We do have a resolution. He'll enter a plea of guilty to the A charge, dismiss the B charge per plea.
Is this a minor or an unclassified?
We're treating it as a unclassified. It's a straight NDO. It's a 45-10-12. And then no accident, insurance was shown.
Mr. Berg, the guilty plea is a complete admission of guilt. This is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to 1 count of driving without a license?
Yes, ma'am.
Counsel, do you waive and stipulate?
We do.
Finding of guilty, he's been here 1 night.
Yes.
Is there anything else?
No, Your Honor.
After I was shown.
No, sir.
1 credit, 1 missed fines and costs. He has 1 violent felony, 1 felony, 2 failures to appear, no misdemeanors. Looks like there Hasn't been anything since 2022. Is there anything from the state on bond?
Your Honor, I'm looking at. I'm sorry,
Kenwood, Raleigh.
2023 you're showing?
I had a Kentucky in 23, or him getting, no, I'm sorry, getting out in 22.
Okay, I have another,
These are PDs, not new charges.
another felony from Hamilton County in 2023, drug charge.
Yes. Okay. Is there anything else?
Judge, I would just like to note that he has received his GED. He's working full-time. I do have a good number for his wife and other connections. He has a good address here. He has resolved the 2 failures to appear that were before us today. We would ask for a supervised OR.
Just stay out of Rally House.
We would stay out of Rally House.
OR plus stay away from Rally House, and I am putting Mr. Berg into random drug urine screens. Cooper,
Thank you, ma'am.
is there anyone here on Cooper? You're here on Cooper? Come on over here. Are you the prosecuting witness, or you're just here for him? Okay, you can have a seat. Thank you. All right.
Plea is not guilty, Your Honor.
Esteban.
Esteban, looks like he has 0 failures to appear, only 1 felony on his record, or a score of 1. I think it's important to note what happened kind of here. Ryan Jenkins is the prosecuting witness on this case. Ryan Jenkins and a couple people, maybe these people right there, had come in to contact. There was a menacing charge placed against a Ryan Schmidt, and by Ryan Jenkins, they've had continual fighting. I believe this is a self-defense argument for us. We would ask for an OR today based on his limited record or a score of 1. I have a good contact for his girlfriend and his grandmother. He works at O'Charlie's almost every day. He's got to be there tomorrow. He is from Cincinnati, graduated from Harrison High School. We would be asking for an OR.
Is there anything from the state?
It looks like he was picked up on a warrant service on this charge. I'm looking at, on the date of the offense, which is October 2nd, it appears he was on felony probation for improper handling a motor weapon in a motor vehicle. It looks like he was placed back on June by Judge Winkler. In this particular instance, he tried to pull the victim from the vehicle, punched the victim in the shoulder, and caused scratches and bruising.
This is from October 2nd.
Yes.
He has the 1 felony for possession of the gun, no failures to appear, no other record, supervised OR.
Stay away, no.
Yes, stay away from the prosecutor. Hartley.
Let's go.
Juvenile court order, Your Honor.
They got me locked up, so. OR.
Mr. Hartley has 1 prior failure to appear, 2 felonies, 6 misdemeanors, but these cases are from 2023, and these are the first times it appears that he was told about the charges.
2 years, 8 months.
Is there anything from the state?
Judge, I think what is concerning is what's listed in the first charge of complaint, or the first, in the bottom of the first complaint. The defendant grabbed his daughter's throat, pushed her to the ground, causing a 911 call, and then would not allow his daughter to exit the apartment. I don't know if there were any charges that arose after that incident.
These cases are from February of 2023. The allegations are serious, but apparently not serious enough for there to be an attempt to pick him up in 2 years. Or
Thank you.
Hopkins.
There is a request for an order of protection. James Hopkins, is James Hopkins in court?
Is he executing the TPO?
Yeah.
Sorry. Disorganized. Those are, yeah.
Judge, the plea is not guilty for Mr. Hopkins. He is executing a temporary protection order right now. Judge, at this point, we are in position to ask for an OR bond. Prosecuting witness here is his father. He does have another place where he can stay. Like I said, he did sign the temporary protection order. He has 0 failures to appear. He does have my card, so he can get in contact with me. So with that, we would just request an OR bond.
Judge, we are a little concerned with requesting monetary bond. Juris, if requested, it appears that this all started over the father maybe finding a needle in the house. So there's some concern about drug use, but what is also most concerning is in the last 2 years, there have been 2 assault convictions, one in 24 and one in April of this year, both in front of Judge Johnson.
On the A, and they're against the same person's cases for. On the A, 5,000 anyway, plus jurors if requested, random urines. On the B, 2,500 anyway. Jones.
TPO sign, sir.
Plea is not guilty. On behalf of Mr. Jones, he is 18 years old. He has 0 failures to appear. He has absolutely 0 criminal history, both adult and juvenile. Judge, we would be in a position to ask for an OR bond. One of our social workers, Isaac Collier, did speak with Mr. Jones earlier this morning to get him set up with services. Additionally, Judge, he does have pretty severe asthma and a heart condition. We believe that earlier this morning he was having a pretty serious panic attack. So they did, remedies were taken to help calm him down. The judge says he's never been in any sort of trouble before in his whole entire life. So we would just request an OR bond from the state.
Your Honor, it appears that he physically went to the protected person's house. I believe that is his mother under this particular order. So we do have concerns about that. The order was somewhat recently issued on July 31st. So, and it looks like this occurred yesterday. That order was still in effect. So we would respectfully request, I don't know if there was a juris or anything attached to it.
There wasn't. It looks like this was common pleas.
Like a
Protection
CTO.
order. OR plus EMD plus jurors if requested. Mr. Jones has no record as an adult or juvenile, no failures to appear.
Judge, would you reconsider the EMU component? We're not sure if you would have an address that would be verifiable.
I won't, because she requests yours, you have to have the EMD. And I usually put a cash bond. The only reason I'm not is because it doesn't say there was actual contact between the parties, and he has no record, no failures to appear. But I am putting juris on this.
Curley. There is a request for an order of protection.
Child account.
Don Shay B. Hannon.
Looks like he's here.
Oh, this was the.
Judge, yes, and I think Mr. Behan is
It's the other case from.
Right.
Yes.
So I think it's somewhat related, but I don't think it's a cross complaint. It doesn't appear to be a cross complaint.
It kind of is a cross complaint. Anyway, the plea is not guilty. Mr. Curley is gonna execute the temporary protection order. Judge, at this point, we would just request an OR bond. He's 29 years old. He lives with his mother. He does not reside with the prosecuting witness. He did sign the temporary protection order. He works full-time at Cable Staffing, where he's been for the past 2 years. He has 0 failures to appear or score of only a 1. This is in my opinion, a cross complaint. The prosecuting witness here came to his home, worked her way into his home, and she's charged with trespass and damaging. But in any event, Judge, I would just request an OR bond. He did sign a temporary protection order, and he doesn't want to have any contact with her from the state.
Thank you, Your Honor. We'll respectfully request monetary bond, EMD, and juris if requested. I have the victim information sheet, which she is asking for juris. The injuries are listed as a broken tooth and a dog bite, and that, and again, from the victim sheet, a knife was used or a weapon was used in this offense. So based on that, we would ask for that, and I guess the TPO would cover no firearms.
Well, Mr. Curley's not a dog, so he didn't bite her
I'm just reading.
because he isn't
what's
a
on
dog.
there. I don't know if a dog was present or a dog was used or unleashed or.
Mr. Curley has 1 misdemeanor, no failures to appear. The police arrested both parties. At this point, the bond is going to be an OR plus the TPO for the parties to stay away from one another. Yes, sir.
Excuse me, good morning, Your Honor. I just wanted to specify the bite. I'm his father, me and his mother are not together. The 2 individuals do have a 1-year-old, so you do have to sort of take that into consideration.
Oh,
But
he's
the other
getting
charges,
out.
I just wanted to.
Time served.
That's fine. He's getting out on the OR.
Appreciate that.
Likens.
Timothy Likens.
He has 1 misdemeanor, 1 failure to appear. Is there anything from the state?
Stay out of Macy's. It looks like both of these are out of Macy's.
Anything from defense?
Judge, we would just at this point request an OR bond. I do have good contact for him and for his father.
OR plus stay away from Macy's. Morgan?
Judge, I think he is waived again. I think he's been waived the past couple of days. At the request of the deputies, I did submit my designation. I have not spoken to him, obviously, because he has been waived for the past couple of days. I'm not sure, like, posturally where we are with this, if it's a probation violation or
It looks like it's a new charge from 1991. I'll put the minimum on it because he has a holder
Yes,
anyway, so it's 250 at 10%. Stokes. Ms. Stokes has no record, no failures to appear. Allegation is she called and made a false allegation to 911. Is there anything from the state?
Nothing additional.
Supervised or?
Thank you.
You're welcome, ma'am.
Judge, I think that's your document.
It is, thank you.
For bond setting, Judge, take both.
Yeah, all this
application for, it doesn't say if they turned something, it just shows they were arrested.